Witness mic test, 1, 2, 3, test, test, test.
Okay.
Hey, Doc. Holding on.
So the Rules Committee will come to order. 3 in 5 workers aged 45 and older have seen or experienced age discrimination in the workplace, according to an AARP survey. And 75% of those workers blame this discrimination for their lack of confidence in finding a new job. So it's not surprising that the Equal Employment Opportunity Commission received more than 20,000 age discrimination complaints in 2017. But in the face of rising age discrimination, the Supreme Court weakened workplace protections in a 2009 decision. Older workers today must prove that their age was the only factor for their employer's adverse action. This is an unbearable burden for workers, and it's a higher bar than victims of other types of discrimination are asked to meet. All victims of discrimination, including older workers, should have their cases heard fairly. That's why we are considering H.R. 1230 today, a bipartisan bill that restores workplace protections to the pre-2009 standard. We are also taking action today to protect students from Secretary DeVos's new rule, which would prevent defrauded students from receiving loan forgiveness. When a predatory college breaks the law or engages in misconduct, students shouldn't be on the hook for crushing debt. And when a college closes unexpectedly, students shouldn't be forced to pay for a degree that they never had a chance to finish. The new Trump administration rule is a slap in the face to more than 200,000 borrowers cheated out of their education by predatory colleges. And this measure will reverse the administration's attempt to rig the rules to benefit the for-profit education racket. This majority stands with students, not predatory colleges. Having said that, I'm now happy to turn to the ranking member, the gentleman from Oklahoma, Mr. Cole, for any remarks he wishes to make.
Thank you very much, Mr. Chairman. Today's hearing covers 2 different bills originating in the Education and Labor Committee. The first I will discuss is H.R. 1230, which changes the burden of proof in age discrimination cases arising under the Age Discrimination in Employment Act. It's intended to overturn a Supreme Court case called Gross versus FBL Financial Services, and allows plaintiffs to bring age discrimination cases if they can show they faced discrimination based on any practice by an employer for which age was a motivating factor. While I think every member of the House would oppose age discrimination in the workforce, I understand that Republicans on the Education and Labor Committee have concerns about the practical effect of this legislation. As such, I'm looking forward to hearing their concerns, and I would urge the committee to make as many amendments in order as possible to ensure that all members may be heard before the final passage of this bill. Our other item is H.J. Res. 76, a resolution arising under the Congressional Review Act that would disapprove of the, quote, borrower defense institutional accountability, unquote, rule recently issued by the Department of Education. Unfortunately, I believe this bill is truly misguided. The Borrower Defense Institutional Authority rule is intended to clean up a rule issued during the Obama administration that was overly broad. The original Obama-era rule set student loan forgiveness as a goal regardless of the cost to taxpayers and did not distinguish between the intentional fraud and inadvertent mistakes committed by a higher education institution. By contrast, the new rule makes sure that students who've been lied to and suffered harm receive relief and still holds institutions accountable for misrepresentations. But it also ensures due process for all parties and allows for the use of arbitration, which could result in additional relief for students, and saves $11 billion of taxpayer money over the previous baseline. Using the Congressional Review Act to disapprove of this regulation will not only prevent the department from issuing this helpful regulation, but it would also prevent the department from ever issuing another regulation on this topic. I don't think this resolution to disapprove is a good use of the Congressional Review Act, and consequently, I would urge both the committee and the House to oppose this measure. With that, Mr. Chairman, I look forward to our hearing, and I yield back.
I thank the gentleman for his statement, and I'd now like to welcome our witnesses to provide testimony on H.R. 1230, the Protecting Older Workers Against Discrimination Act, and H.J. Res. 76, providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Department of Education relating to borrower defense institutional accountability. Chairman Scott, Ranking Member Fox, and Congresswoman Susie Lee, we are delighted to have you here. Anything you brought in writing will, without objection, be entered into the record. I'm now happy to recognize the gentleman from Virginia, Chairman Scott.
Thank you, Mr. Chair. Ranking Member Cole, I'm pleased to speak to you. Bipartisan bill to restore protections against age discrimination in the workplace, which I introduced along with my colleague, Mr. Sensenbrenner from Wisconsin. In 1967, Congress enacted the Age Discrimination Employment Act, or ADEA, to promote employment of older workers and protect older workers from discrimination based on age. At the time, the ADEA was a significant step forward towards prohibiting workplace discrimination. As you mentioned, Mr. Chair, 3 in 5 workers in 2018 saw or experienced age discrimination at the workplace, and as more and more Americans need to work longer, they're increasingly vulnerable to age discrimination. That's why this bill would take a critical step forward in restoring basic rights to older workers. The ADEA's evidentiary standard was borrowed directly from Title VII of the Civil Rights Act, which prohibits discrimination because of age. Thus, for decades, the standard was interpreted to mean that employees can prevail when they show that unlawful discrimination was a motive for adverse employment action, even if it was not the sole motive. This interpretation is consistent with the treatment of claims under Title VII for sex, race, national origin, and religion. So if you can prove that you were discriminated against and age was a factor, then you've made your case. Now, the employer can turn around and say that you would have been fired anyway, or you wouldn't have been hired anyway, to defend. But if you have the so-called but-for treatment as the Supreme Court adopted in 2009 in the Gross decision, you have to prove essentially a negative, that even though you were told that you were too old to be employed, you have to prove that you would have gotten the job anyway. You may not know who got the job or what the relative qualifications are, and there's virtually no way that you can prove the case. In the Civil Rights Act of 1991, Congress codified the mixed motive framework for Title VII, and after that, 19 courts uniformly interpreted the mixed motive, the old way of doing it. 2009, Gross reversed that, and now plaintiffs have to show that they would have been hired or would not have been fired but for age, and that's a standard that is very difficult or impossible to make. The decision in Gross had 2 major consequences. First, it eroded the workplace protections for older workers and it sent a message to employers that they need not treat age discrimination as seriously as other forms of discrimination. Second, the decision opened the door for courts to similarly weaken other civil rights laws, and that's why the bill also addresses the disability discrimination and retaliation against workers for challenging race, sex, national origin, and religious discrimination. After more than a decade since the Supreme Court weakened the ADEA, a permanent fix is long overdue, and that's what this bill does. Under this bill, the plaintiffs would have to prove what they were proving before 2009, and that is that age was a factor in their adverse action. And like I said, if the employer can show the action would have been taken anyway, that's the defendant's burden, not the plaintiff's. So, Mr. Chairman, I hope that you'll report the bill and we can restore older workers' rights to their protection against discrimination. You're back.
Ranking Member Fox.
Thank you very much, Mr. Chairman, and Ranking Member Cole and all of my colleagues for giving me the opportunity to speak against both H.R. 130 and H.J. Res. 76. Like many other Democrat legislative priorities, the Protecting Older Workers Against Discrimination Act, H.R. 1230, was rushed through the committee process without necessary consideration. In fact, the only time our committee considered this issue was in a broad scope hearing on, quote, opening doors to opportunity, end quote, during which the Democrats' own witness said the evidence for H.R. 1230 was not there. If committee Democrats' own expert witness is admitting that data doesn't support the need for this bill, how can they argue that this legislation is appropriate for floor consideration? And don't forget that it's against the law, as it should be, to discriminate in the workplace because of an individual's age, or that employment trends for older workers are positive in recent decades. In 2018, older workers earned 7% more than the median for all workers, compared to 20 years ago when older workers earned 23% less than the median for all workers. Despite these facts, Democrats are moving forward with flawed legislation that doesn't help the people it purports to help. H.R. 1230 overturns Supreme Court precedent and allows a plaintiff to argue that age was only a motivating factor and not the decisive factor that led to the employer's adverse employment action, even though the employer had other legitimate reasons to take the action, such as job performance. Allowing such mixed motive claims abandons congressional precedent, too. Congress has long recognized that different forms of discrimination require different procedures and laws. In 1964, both the House and the Senate defeated amendments to add age discrimination to the Civil Rights Act. Instead, Congress created a separate law in 1967 to prohibit age discrimination, the Age Discrimination in Employment Act. Yet H.R. 1230 imposes the, quote, mixed motive, end quote, standard across 4 very different non-discrimination laws. By doing so, this legislation goes far beyond addressing older workers in the workplace and mandates a one-size-fits-all scheme. To address one of the serious concerns with the bill, I'm offering an amendment to remove the unworkable and ill-advised provision in H.R. 1230 that allows mixed motive claims in Title VII retaliation cases. Allowing mixed motive claims in retaliation cases is unworkable and contrary to the text, structure, and history of the Civil Rights Act. It also puts employers in an untenable position of trying to prove that a legitimate employment decision was not a retaliatory action. In addition to the serious problems I've already laid out, H.R. 1230 hurts older workers and benefits trial lawyers. In most cases brought under the bill, the plaintiff will receive no damages. No damages. Only the plaintiff's attorney will be paid. Most employers will be able to demonstrate to the court that they would have taken the same employment action regardless of the worker's age, and in those cases, the plaintiff will not receive damages. Current law is better for workers who win their cases because if the plaintiff wins, he or she can receive damages, back pay, and reinstatement. Ironically, H.R. 1230 will take valuable resources away from efforts to prevent harassment and discrimination because business owners will be forced to spend money to litigate or settle the increased frivolous trial lawyer instigated legal claims this bill encourages. My opposition to this bill does not diminish my commitment to eliminating discrimination in the workplace to ensure a productive and competitive workforce, which includes older workers who provide valuable contributions to workplaces across the country. Now I'll turn to the other piece of legislation this committee is considering today. H.J. Res. 76 is nothing more than a misguided attempt by House Democrats to undo productive policy the Trump administration put in place to protect defrauded students and American taxpayers. In 2015, a large for-profit school closed, and the Obama administration used this opportunity to issue new regulations on borrower defense that would cost taxpayers $42 billion and encourage tens of thousands of borrowers, whether they were harmed or not, to apply to have their loans forgiven. The 2016 Obama regulation created more chaos than clarity and set massive loan forgiveness as a goal, regardless of the cost to taxpayers. The Obama regulation did not distinguish between fraud and inadvertent mistakes made by schools. The difference between the two is critical because the Education Department can levy significant financial penalties on institutions found to engage in fraud, which can cause a school to have to close despite no intentional wrongdoing. Most schools do not have a reckless disregard for the truth. Many schools could face harsh financial penalties, forcing them to close, leaving millions of students without access to their higher education opportunity. President Trump acted quickly to better protect borrowers and taxpayers and created the 2019 Borrower Defense Rule. Among other benefits, the new rule delivers relief to students who've been lied to and suffered financial harm, saves taxpayers $11 billion by helping students complete their education rather than indiscriminately closing schools, holds all institutions, not just for-profits, accountable for misrepresentations, and ensures due process for all parties. Bottom line, the Education Department's Borrower Defense Rule protects student borrowers, holds higher education institutions accountable, saves taxpayers $11 billion. HJ Res 76 would repeal the Trump administration's rule and go back to Obama regulations that harm students and taxpayers. Thank you, Mr. Chairman. I yield back.
Thank you very much. Ms. Lee?
Thank you. Thank you, Mr. Chairman, Ranking Member Cole, and all the members of the committee. This is the first time the House of Representatives will consider the Congressional Review Act in the 116th Congress. Many of you have been here for a while, voted on several CRAs before, but for my fellow freshmen, the CRA is a resolution of disapproval that allows Congress to overturn recent regulatory actions of federal agencies that do not reflect the original intent of the authorizing legislation. My resolution would overturn the U.S. Department of Education's 2019 Borrower Defense Rule. Before I get to why we need to overturn the new rule, I want to delve into some recent history and elaborate on why the Borrower Defense Rule is important to our nation's students. Predatory colleges have been at the core of scandals for decades. Going back to the 80s, the scandals surrounding predatory schools were so severe that President Reagan's education secretary, William Bennett, called it, quote, an outrage perpetrated not only on the American taxpayer, but most tragically on some of the most disadvantaged and most vulnerable members of society. That is what led to the 1992 Higher Education Act that had the first regulations and guidelines to borrower defense relief. Fast forward to 2015, Corinthian colleges collapsed overnight, leaving 16,000 students without options to finish their degrees and with mountains of debt. Shortly thereafter, in 2016, ITT Technical Institute abruptly shuttered, leaving 40,000 students, including 7,000 veterans, in the same predicament. These collapses came following years of documented predatory behavior. These students were defrauded, plain and simple. They were lied to about the prospects for getting a job after graduating. They were lied to about their credits being transferable, and they were lied to about the quality of education they would receive. These were not unintended errors. In 2016, the previous administration issued a new borrower defense regulation that not only created a streamlined process for defrauded student borrowers to apply and receive relief, but it also protected taxpayers by holding these predatory institutions accountable for the cost of the loan relief due to fraud. When Secretary DeVos took over the Department of Education, she rewrote the Borrower Defense Rule, which makes it unreasonably difficult, actually nearly impossible, for borrowers to apply successfully for relief, severely restricts how much relief borrowers can receive, and shifts the cost of providing debt relief from predatory schools to taxpayers. This injustice is not just hypothetical. Look no further than the FTC's record $190 million settlement against the University of Phoenix. The university used deceptive ads that gave the false impression that the University of Phoenix partnered with high-profile companies like Microsoft and Twitter to place students into jobs. In the words of the FTC's director of the Bureau of Consumer Protection, quote, students making important decisions about their education need the facts, not fantasy job opportunities that do not exist. But guess what? Under this 2019 rule, Most, if not all of those students that were deceived by the University of Phoenix in 2012 and 2013 won't even be eligible to seek the loan relief that they had the right to under the HEA. It's clear that the 2019 Borrower Defense Rule prioritizes enriching predatory schools over protecting defrauded students and American taxpayers. The change taken on hold to the 2019 rule will result in fewer defrauded students seeing the relief they are entitled to under the HEA. According to outside analysts using the Department of Education's own data, it is estimated that under the 2016 rule, 53% of the eligible loan debt would have been discharged. Under the new rule, that number drops to 3%. This is because the new rule creates an outrageously high burden of proof for defrauded students to get relief. Under the new rule, borrowers would have to prove that the institution engaged in misrepresentation deliberately. Even when that same institution has clearly violated the law, that is not enough proof for the student borrower that cannot prove intent. They must also prove intent. As many of my colleagues who are lawyers know, it sometimes involves huge investigations over many years to find this type of evidence. For working students with families on a budget now, with a debt load, hiring a lawyer is not realistically or possible. And more importantly, defrauded students should not need a lawyer to get relief. The argument you will hear over and over again from the 2019 Borrower Defense Rule proponents is that the 2016 rule was way too costly to taxpayer, and the new rule saves taxpayer dollars. If saving money was the true goal, the new rule would keep in place the early warning system that the 2016 rule that gave the department greater oversight of an institution's financial health. That is not the case. The 2019 rule weakens the early warning system created that ensures predatory schools facing allegations of widespread fraud are forced to set aside money to cover the potential cost of debt relief. According to analysis based on the Education Department's own data, the changes to the early warning system will result in institutions repaying only 1% of debt relief for defrauded borrowers. The other 99% will be paid by taxpayers. So as you can clearly see, the 2019 rule makes it harder for defrauded students to receive relief. The Higher Education Act gives students the right to relief, and this rule blatantly thwarts congressional intent. If we believe every student deserves a shot at success, if we believe that businesses should be held accountable for fraudulent behavior, and if we truly believe that education is a national priority, then we must overturn the 2019 Borrower Defense Rule and pass this resolution. Thank you.
Thank you very much. Mr. Cole.
Thank you very much, Mr. Chairman. I'd ask first unanimous consent to place a statement of administration policy on H Joint Res 76 into the record. It merely tells us that the President's advisors would recommend a veto of this legislation were it to pass.
Without objection.
Thank you very much, Mr. Chairman. Ms. Fox, let me ask you, it's my understanding that the Trump administration put forward the new borrower defense rule in large part to deal with some of the serious and significant problems as a result of the Obama administration's rule on the same issue. Can you expand on the Obama administration's regulations and how they negatively impacted college students and institutions?
Well, it goes after only one segment of the population and one area that serves students in the country. We need programs that go after all of the schools in the country. We don't want us to be targeting just one area. We need, the Obama administration went haywire when they decided to allow for group borrower discharges and blur the distinction between what acts or omissions constitute fraud versus an inadvertent mistake. Many institutions, including HBCUs and public flagship universities, were concerned a single marketing error, such as not updating graduation rates, in promotional flyers could set off a domino effect of borrowers seeking and receiving forgiveness. Institutions would be on the hook for this debt and could close due to financial pressures. This would deny students their education, act as an economic drain on the community, benefiting from the institution's business, and harm taxpayers who may be ultimately responsible. This rule will do a much better job of handling the situation because the students will be handled on a case-by-case basis. Obviously, I mean, I made my living in the education world for a long time, and what I went to work for every day and what I still come to work for every day is to say that I want students to have a better life, like I did, as a result of education. But the rule established in 2016 does not do that.
And just following up on that, how does the current rule, which is the subject of this disapproval resolution, do a better job than the previous rule that the past administration passed?
Well, the rule, we've been told that this rule will shield predatory schools from accountability, and it's just a giveaway to for-profit schools and at the expense of students. But that is just simply not the case. We want this rule to apply to make sure that no one is above the law, including for-profit institutions. There are no carve-outs, there are no special giveaways. There's simply a standard that all institutions will be held to. Nothing in this rule prevents a borrower from filing a borrower defense claim before or doing an arbitration proceeding. We think arbitration would take us much closer to getting settlements for the students. The 2019 regulation dictates that any institution that uses those tools must disclose this information to students using plain language. Importantly, borrower defense can only compensate borrowers for their federal obligations, but arbitration can award students for other methods of payment like cash transactions or private loans. And we believe that arbitration will, again, settle things in a much quicker way.
Dr. Fox, I'd like to ask you a series of questions, if I may, that might clear up some of the misinformation surrounding the rule. Is it true that the rule eliminates, that this rule eliminates $11 billion in relief for defrauded borrowers?
Absolutely not. This is a myth. The reason this rule saves $11 billion is because it is scored off the 2016 rule baseline, which, as you know, was projected to cost taxpayers $40 billion. Because this rule does not prematurely shut down institutions, it will not be as expensive as the Obama rule, which is why there's a savings associated with the 2019 regulation. It cannot be stated often enough, students have been the victims of fraud and who have consequently suffered as a result are entitled to and will receive loan relief under the 2019 regulation.
Okay, and is it true that the rule shields predatory schools from accountability, that it's just a giveaway for profit colleges at the expense of students?
Absolutely not. Again, nothing could be further from the truth. All institutions, regardless of their tax status, must be held accountable. This rule makes sure no one is above the law, including for-profit institutions, as I said before. There are no carve-outs, no special giveaways. That's a standard they're all held to. I was very frustrated under the Obama administration when there were occasionally clear warnings that schools were going to be in trouble. And instead of the department helping those schools stay in operation until the students could be helped and could work out their plans, get their transcripts, transfer, they were just arbitrarily shut down. What this does is go after the institutions, doesn't really try to help the students, and that's what we ought to be about.
And is it true that this rule, by eliminating the prohibition on class action bans and mandatory arbitration clauses, denies students their day in court?
No, as I mentioned before, nothing in the rule prevents a borrower from filing a borrower defense claim before or doing an arbitration proceeding. The 2019 regulation dictates that any institution that uses these tools must disclose this information to students using plain language. Borrower, as I said before, borrower defense can only compensate borrowers for their federal obligation under the Obama ruling, but arbitration could award students other methods of payment like cash transactions or private loans.
And finally, is it true that the rule needlessly requires borrowers to apply individually for relief rather than receiving automatic discharges, even when a group of borrowers has been harmed by widespread fraud or misconduct?
Well, I do want to say that the group versus individual dynamic in this rule is somewhat complicated, but here's what's true. The Secretary can determine it would be more efficient to establish misrepresentation was made to a group of borrowers. However, the individual borrowers in the group will undergo separate determination to evaluate if he or she suffered financial harm as a result of the alleged misrepresentation. Each student deserves individual consideration, and it would be improper for the taxpayer to forgive the loan of a borrower who went on to benefit greatly from the education he or she received, which is what the Obama rule allowed for. The important thing to remember is this rule, unlike the 2016 regulation, provides due process, fundamental fairness to all parties involved in post-secondary education.
Thank you very much. Yield back, Mr. Chairman.
Have committed fraud repaying only 1%.
Known
of it-
institutions that have
The
committed
institutions
fraud.
themselves versus 23% under the 2016 rule. I must also remind the committee that this administration fully rescinded the gainful employment rule, which without any provision to replace it would end up costing taxpayers $6.2 billion in increasing spending on Pell Grants and student loans. So it seems to me that if everyone were interested in saving taxpayer money, they shouldn't have supported rescinding this rule in the entirety. But finally, if the Department of Education, my colleagues, were truly concerned about cost, then this estimate should encourage the department to tighten its oversight and prevent federal student aid dollars, including loans, from flowing to institutions that are defrauding students in the first place. The only reason that this is estimated to save money is because the 2019 rule denies relief to borrowers with rightful claims.
And can I make a comment?
Absolutely.
And I think that's the point. Whatever savings you're talking about, that's defrauded students that didn't get relief and are having to pay back the loans to colleges that defrauded them. And there's a couple of things that the ranking member pointed out. No class actions, unnecessary time limitations, which will create bizarre situations where roommates equally defrauded. One gets a message and files his individual claim. The other one kind of sleeps through the deadline. Then that's what he's going to have to pay his loan, and that's going to save. That's where some of the savings goes. There's no reason for the deadlines. If you find out that you were defrauded, that your so-called degree is actually worthless, that you finally want to transfer some of the credits that you were told were transferable, and find out then you can't transfer them, and if everybody similarly situated has been defrauded, why can't you have a class action? Why does each person have to figure out his individual situation, and file an individual case, go find an individual lawyer, each and every one. A lot of them will not get around to doing that. They will be defrauded, they'll have to pay off their loan, and that's where the savings come from, because they'll be saddled with that debt.
I wanted to address one other thing. The statement that the 2016 rule differentiated between classes of schools is not correct. The 2016 rule applied to all schools in the same manner. It just so happens that for-profit schools were the ones that had the most defrauded students because they acted in this way that actually defrauded students. So I think it was over 80% of the BD claims were for for-profit schools. It's simply the nature that these schools have the profit incentive that leads them to engage in that activity that defrauds students.
Ms. Fox, in no way, I just want you to know that in no way does my next statement refer to you. It's just your name happens to be Fox. Have any of you heard of the saying, the fox guarding the hen house? Not talking about that fox again. She's a lovely fox.
Thank you.
I want to read, and I know the letter has already been included for the record, but this is a statement of the administration policy. In the administration, according to this letter that was given to us, it states, the very first paragraph, the administration strongly opposes passage of HJ Res 76. The resolution would undermine the administration's effort to protect students and taxpayers by nullifying the Borrower's Defense Institutional Accountability Rule published on September 23rd, 2019. HJ Res 76 would restore the partisan regulation regime of the previous administration, which sacrificed the interest of taxpayers, students, and schools in pursuit of narrow ideological objectives. So when I said a case of the fox guarding the hen house, it is true that despite a court order requiring Secretary DeVos to process claims for 170,000 students, she still has not done it and refused to do it. The Obama-era rule actually ensures that known and proven predatory schools facing allegations of widespread fraud are forced to set aside money to cover the potential cost of debt relief. So we have rules for local governments and state governments that they must have a rainy day fund. In essence, this would be a rainy day fund, is how I view this, for those people that have proven to be abusers of the young people, like the people in my district that have been defrauded by a promise of an education that will help them, as my colleagues would say, raise themselves up by their bootstraps. They are not asking for free anything. These are loans that they are more than willing to pay back. But we have to do our part to ensure that we're protecting these desperate young people that are trying to make a better life for themselves. The department's own data has said that changes to early warning system will result in institutions repaying only 1% of debt relief for defrauded borrowers. So who are we trying to protect here? We're trying to protect the known thievery that continues to happen in our communities. And let me just say, the poor people of the 35th Congressional District in California, or the 16,000 people that you cited with Corinthians, are not the only ones that are being defrauded here. Because more and more, our veterans are being targeted because of the GI Bill. How do I know this? Because I personally have seen the emails, because my son is a veteran. So we also know that the Trump University the court had to order them to pay back a $25 million settlement to the students that they defrauded. So once again, we're talking about the fox guarding the henhouse. And if not Congress, and if not for good policy, why would we continue to allow, if we truly want to defend taxpayers and protect our students and protect our veterans, why would we choose to continue to protect the people that we know have continued to abuse them and continue to defraud them by promising something that they know themselves they cannot prove? I think it's unconscionable to ask a young person to pay up money and to hire an attorney to try to jump through all of these loopholes, to try to prove their case, when many of these organizations have already been shown that they are not worthy of continuing to operate in the way which they have operated. So with that, I would encourage my colleagues to support this legislation, and let's move forward and continue to protect our students, because we can't depend on this administration to do that. And I
Has lost employment opportunities, the drag it is on our economy. So the financial pressure of student loans today, both because of the increase in costs and wage stagnation, means that the pressure on our student borrowers is obviously much higher than prior generations. And it's been exacerbated by bad actors like for-profit universities who've tried to game the system and defraud students by persuading them to take out loans that leave them with crushing debt and degrees that aren't worth the paper they're printed on. So I believe it's important, if the federal government is going to be in this space, that we're acting to protect our borrowers and not to put our thumb on the scale to benefit businesses that are trying to shift costs to taxpayers. So with that, I guess I'd like clarification, Mr. Chairman, if you can just tell us a little bit about how flipping the switch back to the Obama-era regulation is more beneficial for our student borrowers.
Well, I think the questions that the ranking member asked, I think, point out to a lot of the problems in the new regulation. No class actions. You can imagine 10,000 students, each with a claim. How many of them will not bring the claim because they can't figure out what the process is? Okay, that's how you save money. They're saddled with that debt that they should have been relieved of. There are time limitations. If you didn't find out within the time limitation that your credits were not transferable, like you'd been told they were, then you lose your case and you're saddled with the debt for these worthless credits. All of the money that's saved, there's also a calculation in what portion, if you've been defrauded, you shouldn't have to pay any of it. There's a formula in there that tries to calculate how much you're entitled to, and that's where that 1% comes from. A lot of people can prove that they were defrauded, prove that they were lied to about transferability of credits, and because of the formula, they don't get any relief. So if you've got two colleges equally bad, One of them just lied to get their students, the other one told the truth. The ones that were lied to get no relief because the comparative college was just as bad, and there's no what they call damages. Well, no, you were lied to, and you're entitled to borrow defense. That's what it's all about. And all of these savings, billions of dollars in savings, that represents students who are saddled with debt that they shouldn't have to pay. And that's what this regulation does to them.
And I certainly share your concern about, the forced arbitration clauses or the ban on class actions. In fact, I've introduced a bill that would forbid those kind of clauses because we recently had judiciary hearings about the impact on student loan borrowers and the fact that it is very difficult for them to pursue action if they can't do so collectively.
If you got 10,000 people, what sense does it make to require each of them to hire an individual lawyer to process the individual case? And just look at the expense and all of that. If you have a class action, everybody can get, if they cheated everybody, then everybody has essentially the same case.
That would seem inefficient, but thank you. I yield back.
Thank you, Mr. Chairman. I guess I'll have plenty of opportunity to talk about this on the floor tomorrow, but Chairman Scott, let me just ask you, last Congress, we got a lot of, probably had more experience with Congressional Review Act cases than any previous Congress. I think the one before that was March 20th, 2001, so it had been a while. But as I recall, you're going to have companion Senate legislation, so you do have a Senate sponsor and companion legislation that is likely to pass the United States Senate?
Dick Durbin, yes.
It's pending over in the Senate. Well, you can have companion legislation, but one resolution would have to pass both bodies.
Correct. So just recalling some of the experiences we had with, it's not easy to get Congressional Review Act, to get a rule rescinded. We did manage to do it a few times in the last Congress. Where is the Durbin legislation at this point?
It's still pending in the Senate.
Has there been any talk of having it,
Well, they're working on it. They're getting additional co-sponsors on the legislation. It's going through the normal process. But I don't think we should limit our consideration.
not saying that we should, just
what the,
merely asking for information for scheduling purposes, as we say sometimes? Dr. Fox, let me just ask you on the other legislation.
I've just been informed they may consider it within the next few days.
Very well. Just ask you, is age discrimination already illegal?
It certainly is.
I thought so. When I was an employer, I think I understood that.
Right. It certainly is.
So does this legislation before us embellish that in some way?
It makes it harder to prove age discrimination. As I said in my comments, we don't want any kind of a discrimination, and this will make it much harder for people to prove age discrimination. And they're not likely to get any money as a result of doing it. Their lawyers will, but they won't.
And I think that, I think you've hit on the crux of why we're doing this. Well, thank you, Mr. Chairman. I'll yield back.
We have private for-profit colleges, but we have a pretty strenuous regulatory framework that I think has protected students. And obviously, given the collapse of Corinthian and ITT Tech and others, you think about the financial wherewithal of these schools as they're trying to attract students. And I'd like to ask Ms. Lee, and I appreciate her introduction of this legislation, but as I understand it, the rule, and others could comment as well, but the department's job is to ensure that the colleges and universities are financially sound before they receive student loan dollars. The whole notion being we should be as proactive in making certain that when students are applying, not only for student loans, which is the focus here, but also just paying tuition and enrolling in these schools, that their financial wherewithal is as strong as possible. We want them to, so as I understand it, the rule actually reduces the amount of financial institution and information institution should give to the department, and seems to me that will make it more likely that we will have failing schools in the future. And it's so, one of the things that I find most disturbing about the rule as it's proposed, and one of the reasons I support the underlying legislation, is because it seems to me it opens the door and makes more likely that people would have to assert the borrower defense rule in the future. I just wonder if you could comment on that.
Yeah, no, originally, when we saw a lot of this fraudulent activity, the department put in what they called triggering events. And these were things, whether it was you saw more than 30% of the students defaulted on their loans, you saw a certain number of widespread claims that were being filed by the school, and then there were also financial tests. And if the school fails certain number of these, then they're required to be under watch and further oversight. And then if it gets to a certain point, they must produce a line of credit, which basically protects taxpayer dollars. And those protections are eliminated under this.
And as I recall, I may be wrong, but as I recall, I think I specifically asked Secretary DeVos about letters of credit for these defunct institutions and found out that the letters were not current. I don't know if the department has done anything in response to that, but again, the weakening of financial institutions and essentially the stress tests seems to me to make it more likely we'll have students defrauded in the future. So I appreciate, I don't know if there's others who have comments.
Yeah, no, under the Department of Education's own estimates, it expects that misconduct by predatory schools will impact hundreds of thousands of more students. In fact, 200,000 in 2021 alone.
Yeah, and I'll just say this in closing. I also asked the Secretary during the hearing of Education and Labor that the question of getting essentially accreditation ought to mean something. There was a suggestion, and it has been made by the Secretary and by the Department, that students need to do their own due diligence here, as though accreditation shouldn't be enough. And I just think it's, not to beat a dead horse here, but the notion of putting more responsibility on the students, who in many cases they are non-traditional students who are looking at these institutions, to require them to do greater sort of due diligence and looking for, having to test the validity of the claims themselves. And now with the rule weakening financial standards and stress tests, I think we're just asking for a whole host of problems in the future, and obviously putting a number of potential students and current students at risk. So thank you for your work on this.
Them access to federal aid, it's our responsibility to hold them accountable. I actually, over the weekend, looked at the new rule and tried to figure out, if I was a student, what kinds of material I had to present to make my case. And it's a bureaucratic nightmare. Now, if it's a bureaucratic nightmare for me, I can imagine for the students that are attracted to these institutions, who are the most vulnerable higher education students in our country. So I could not assemble all those materials. And it was very complex and literally a bureaucratic nightmare. Let me ask you, how many Americans have been victims of predatory institutions? And do you have some numbers on that?
There's approximately 240,000 pending borrower defense claims that this Department of Education has yet to process. Like I just stated, the Education Department predicts that there will be 200,000 individuals in 2021 that will be subject to this behavior, not to say that they will all be claims. But this illustrates the scope of the problem. In my home state, there's over 3,000 pending claims. New York, 7,500. In Florida, your home state, 19,000. And in California, over 41,000. You know, and what you stated, I wanted to comment on, gets really to me to the point of this resolution. You know, I think about my time when I applied to school. I'm, you know, one of 8 children. My father went to school. I did not have a counselor and my parents looking at every piece of documentation that I looked at. I pretty much did it on my own. And basically, under this rule, I'd need to be aware of that I was signing away at certain schools any chance of arbitration or filing a class, even if I knew what that meant at that time. Again, most of these victims are low-income, low-information students. Then I'd have to be prepared to demonstrate that not only did the school defraud me or lie to me by saying that I was going to get a specific job or that my, you know, my course credit would be transferable, but that I'd have to demonstrate that not only did they lie to me, but that they intended to. So basically, this is now the average, the median debt that these students have who have these claims is $11,000. So you think about it, these are, again, low income, low information students. They now have $11,000 in debt. Their credit score is being plummeted because of this. And now, in order to get justice, they're going to have to hire an attorney to prove intent of an institution that has already been found to engage in that behavior. And you know, when you talk about the cost saving of this, it's really because it's nearly impossible for anyone to get any type of relief under this. And, you know, this isn't about giving relief to someone who, you know, didn't like their dorm room. This is about these companies, these institutions calling up kids, persuading them to take out loans, sometimes veterans who are already covered with GI benefits, persuading them to take out additional loans in addition to the GI benefits to join their school. So it's a pretty egregious rule, in my opinion, and why the underlying purpose of this resolution.
Yeah, let me just say finally, I think it's unethical for us to create a bureaucratic nightmare for these students in the name of saving money for the taxpayers. I yield back.
Mr. Chair? Yes. Can I ask unanimous consent that letters from Leadership Council on Aging Organizations, which include the AARP, AFL-CIO, National Committee to Serve Social Security and Medicare, and a number of others, Consortium of Citizens with Disabilities, and another letter from a long list of organizations in support of the in support of the legislation 1230. And also on that, the comment was made that the bill would make it harder to prove. Right now, it's almost impossible to prove. This will make it a lot easier to prove. All you've got to do is show that age discrimination was a motivating factor, and then the burden goes to the defendant to have the information. If you've applied for a job and they say, well, you're too old, and you don't get the job, you don't know the qualifications of the person that got the job. You don't have any information, so you really can't prove your case. This will make it much easier.
Seeing none, I'd like to thank our witnesses for being here today, and please leave anything you would like inserted into the record with our stenographers, and you are now free to go. We're delighted that my friend, Mr. Davis, is our next panelist. Anything, sir, you brought in writing will, without objection, be entered into the record. I now recognize the gentleman from Illinois, Mr. Davis.
Thank you, Chairman
So this is the
Hastings
one.
and Ranking Member Cole, for allowing me to speak on my bipartisan amendment to H.R. 1230, the Protecting Older Workers Against Discrimination Act. I'd like to thank
Hold
my
on just a
friend.
minute, Rodney. If you all that are leaving would leave. Thank you, Rodney. may
Thank you
proceed.
again, Chairman Hastings. I'd also like to thank my friend, Congressman Mark DeSaulnier, for his co-sponsorship, and Chairman Scott for his support for my amendment. I'm humbled by the number of members who decided to co-sponsor this amendment, including Representatives Shelley Pingree, Elise Stefanik, Haley Stevens, Jennifer Gonzalez Colon, Marcy Kaptur, Abigail Spanbarger, Betty McCollum, David Trone, Chris Smith, Pete Stauber, Will Hurd, and my Illinois cohort, Mr. Mike Bost. This is an important bill, which I was proud to co-sponsor. The bill provides a critical fix caused by the outcome of the 2009 Gross versus FBL Financial Services, Inc. Supreme Court case by assuring that older workers can seek justice on a level playing field. According to a 2018 report from the Equal Employment Opportunity Commission, women, especially older women, but also those at middle age, were subjected more to age discrimination than older men. My amendment is simple. It highlights the fact that women face age discrimination at higher rates and would require the Department of Labor and the EEOC to conduct a comprehensive study on these age discrimination cases. DOL and EEOC would then be required to make recommendations for best practices to combat age discrimination of women in the workplace so that employers are better able to make conscious efforts to address the issue. Earlier this Congress, I was proud to cross party lines and vote for several bills that address the unique challenges that women face, including the Paycheck Fairness Act, the Violence Against Women Reauthorization Act. And I would like to remind everybody in this room, these issues, they're not Republican or Democrat issues. They must be addressed. We can do better, not just because we're dads or husbands, but because it's the right thing to do. Chairman Hastings and Ranking Member Cole and the members of this committee, thank you for your consideration. I hope you'll make this important amendment in order, and thank you, and I yield back.
Does any member wish to ask Mr. Davis a question? Seeing none, Mr. Davis, you're excused. Does
Thank
any
you all.
other member of the committee?
Mr. Chairman, could I
Of course, Mr.
just
Scott.
go on a
I knew
record-
if you were hanging around here that Mr. Davis was in trouble, but go ahead.
just to confirm his statement, that I support his
All right.
amendment.
Thank you. Does any other member of the committee wish to ask a question? Seeing none, I'd like to thank our witnesses for being here today, and please, anything you have inserted into the record. There are no more witnesses. Are there any other members who wish to testify on H.R. 1230 or H.J. Res. 76? Seeing none, this closes our hearing. I am a bearer of somewhat bad news. Without any other objection, the committee stands in a very brief, I hope, recess. Subject to the call of the chair. How brief? Very brief, they say.
Okay, all right, here we go. Okay, the Rules Committee will come to order. At this time, the chair will entertain a motion from the distinguished gentleman from California, Mr. DeSaulnier.
Thank you, Mr. Chairman. And Mr. Chairman, I move the committee grant H.R. 1230, the Protecting Older Workers Against Discrimination Act, a structured rule. The rule provides an hour of debate on the bill, equally divided and controlled by the chair and the ranking member of the Committee on Educational Labor. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute consisting of the text of Rules Committee Print 116-46 shall be considered and adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes in order only those amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by the member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and the opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report. The rule provides one motion to recommit with or without instructions. The rule provides for consideration of HJ Resolution 76, providing for congressional disapproval under Chapter 8 of Title 5, the United States Code of the Rules submitted by the Department of Education relating to border defense institutional accountability under a closed rule. The rule provides 1 hour debate on the joint resolution, equally divided and controlled by the chair and the ranking member on the Committee of Education. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides one motion to recommit. Section 3 of the rule provides that on any legislative day during the period from January 17th of 2020 through January 24th of 2020, the journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and time to be announced by the chair in declaring the adjournment. The rule provides that the Speaker may appoint members to perform the duties of the chair for the duration of the period addressed by Section 3. And finally, the rule provides that each day during the period addressed by Section 3 shall not constitute a legislative day for the purposes of Clause 7 of Rule 15.
You heard the motion from the gentleman from California. Is there any amendment or discussion? Mr. Cole.
Thank you very much, Mr. Chairman. You know, we haven't had an opportunity to have an open rule yet this entire Congress, and so I wanted to provide that opportunity on H.R. 1230 for a couple of reasons. First, we don't have a particularly busy legislative agenda this week, so this is not going to...
As far as we know.
Well,
Yeah.
I rely on you. You're my North Star on this, and just looking at the schedule, it doesn't look like it's going to be a backbreaking week so far. So anyway, I thought this might be a good, and I actually think this is an area where there's a great deal of commonality, and I think if we let members bring their ideas to the floor, we might significantly make this much more bipartisan than it already is. So would offer an open rule on H.R. 1230 as an amendment.
Heard the gentleman's amendment. Any discussion or comments? Hearing none, the vote is on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. Being the chair, the noes have it. Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? Mrs. Torres, no. Mr. Perlmutter? Mr. Raskin? Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
3 yeas, 7 nays.
Amendment is not agreed to. Are there further amendments?
Mr. Chairman.
Mr. Woodall.
Mr. Chairman, I have an amendment to the rule to make an order amendment number 3 offered by Ranking Member Fox. There just weren't that many Republican amendments offered to this bill. Of the 3 that I see, 2 of them related to the issue of attorney's fees and whether or not attorneys should be collecting money when plaintiffs are not collecting money. The Supreme Court has spoken to the issue of mixed motive claims and the combination of mixed motive claims and attorneys fees being awarded is the source of not only concern for the ranking member, but for many of us. I would hate to see an effort to help students, as Ms. Shalala described, brought down by a disagreement over attorney's fees and litigiousness in this country, and making the Fox Amendment in order would allow us to answer that question.
Heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Woodall amendment. All those in favor say aye.
Aye.
Opposed, no. No. Being the chair, the noes have it.
Roll call, please.
Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? No. Mrs. Torres, no. Mr. Perlmutter? Mr. Askin? Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Mr. Cole, aye. Mr. Woodall?
Aye.
Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
3 yeas, 7 nays.
Are there any other amendments? Dr. Burgess.
Yes, Mr. Chairman, I do have an amendment of the rule. I move that the committee amend the rule to provide for consideration of H.Res. 783, honoring the members of the military and intelligence community who carried out the mission that killed Qassam Soleimani, and for other purposes under an open rule. As Mr. Cole has already pointed out, we don't have just a crushing legislative load this week. This is the resolution that was offered along with the motion, on the previous question last week on the rule, and had the previous question been defeated, this resolution could have been considered. But this is a reasonable resolution offered by Representative Dan Crenshaw of Texas, himself a decorated Navy SEAL. He introduced H.Res. 783, recognizing our troops and intelligence personnel who carried out this dangerous mission. Last week, again, I unsuccessfully tried to obtain a floor vote on the resolution as part of the defeat of the previous question. Mr. Chairman, regardless of how you feel about the President's actions, Congress should take the time to honor the men and women who put their lives on the line every day. We can agree there's no better time to come together in support of our brave men and women defending our country. This resolution deserves a vote on the House floor. Again, we're not under a crushing legislative load this week, and it would provide us ample opportunity to honor those who have served us so well. And I ask an aye vote on the amendment.
Yeah, well, I thank the gentleman. I don't think it's at all germane to the topic that we're discussing here today, but let me reiterate what I said on the House floor. If we really want to honor our troops, it won't be with words or press releases. It's going to be with doing our job. And one of the jobs that we ought to be doing here is we ought to, when it comes to issues of war, we ought to have the guts to debate these wars and vote on them. We owe it to our troops. We owe it to their families. And for too long, under Republican and Democratic administrations, we have shirked our responsibility. And I think that's a great disservice to the men and women who serve our country. But appreciate the gentleman's amendment. I would urge.
Mr. Chairman,
Yeah.
if I could speak to the issue of germaneness, and once again, we are the powerful House Rules Committee. We can do really literally anything we want. And we do have two concepts that are essentially unrelated concepts that we're considering under this rule. So this is not that much of a stretch. And again, as Mr. Cole pointed out, we're not under a crushing legislative load. I think this would be an appropriate time to offer this.
Well, you know what? I think what I'll do is I'll work with our majority leader to see whether or not he can bring a suspension to the floor that will honor our troops. Again, I think all of us honor the men and women who serve our country, but I think we dishonor them by our inaction and by basically giving up our authority to the executive branch when it comes to war. It doesn't take a lot of courage for members of Congress to get on the House floor and talk about the issues that we talked about on the floor yesterday without having to take a vote on whether or not we should be in these conflicts to begin with. So I would urge a no vote at this time. All those in favor of the Burgess Amendment say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings? No. Mr. Hastings, no. Mrs. Torres? No. Mrs. Torres, no. Mr. Perlmutter? Mr. Askin? No. Mr. Askin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. DeSaulnier, no. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
3 yeas, 8 nays.
Amendment is not agreed to. Any further amendments?
Chairman, if I could just ask a question of the chair.
Yep.
I really expected this to pass, so I wasn't prepared to deal with failure of this amendment, but I do recognize you made a very generous offer to speak to the majority leader about perhaps bringing this concept up on suspension, and I would just offer to be helpful to you in any way.
I appreciate that.
To make
I
this
will.
happen. I think that would be a reasonable approach to move forward on this.
I hope we can come up with I would like to think we come up with a bipartisan resolution to be able to honor the men and women who serve our country with such great bravery and distinction. So thank you. And no further amendments. The vote is on the motion from the gentleman from California. All those in favor say aye. Aye. Opposed, no? No. Opinion of the chair, the ayes resoundingly have it. The clerk will call the roll.
Mr. Hastings. Aye. Mr. Hastings, aye. Mrs. Torres. Aye. Mrs. Torres, aye. Mr. Perlmutter. Mr. Askin. Aye. Mr. Askin, aye. Ms. Scanlon. Ms. Scanlon, aye. Mr. Morelli. Mr. Morelli, aye. Ms. Shalala. Aye. Ms. Shalala, aye. Mr. DeSaulnier. Mr. DeSaulnier, aye. Mr. Cole. No. Mr. Cole, no. Mr. Woodall. Mr. Woodall, no. Mr. Burgess. No. Mr. Burgess, no. Mrs. Lesko. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk, report the total.
8 yeas, 3 nays.
Motion is agreed to. The gentleman from California, Mr. DeSaulnier, will carry it for the Democrats.
And the gentleman from Texas, Dr. Burgess, will carry it for the...
And I think that is the conclusion of our business, and hopefully maybe for the week, I hope. And with that, the Rules Committee is adjourned.